Maloney, I'm sorry.
Thank you, Mr.
You're both
Chairman.
New York, but I know the difference.
Right. And Ranking Member for calling this important hearing, and I join my colleagues in expressing our condolences and support to the Terry family. And I thank all of the professionals in law enforcement for your work and your bravery. And I especially want to welcome Special Agent Forcelli, since I used to have the honor of representing the beautiful Bronx, where you served, and I appreciate your statements in support of the AFT in New York in their fine work. I would like to ask you, Special Agent Forcelli, some of the specific statements in your testimony to try to get a better understanding of what evidence is necessary in order to get a conviction in these cases. And if I understand this correctly, there is no federal statute that specifically prohibits straw purchases. Is that correct?
No, ma'am. There is a statute, but the statute doesn't carry significant jail time. And candidly, I mean, I had great success working with Preet Bharara and several administrations before his with the U.S. Attorney's Office in New York, and we used basic techniques. You arrest the people who are the bottom feeders, the lower people in an organization, and then you proffer them. You gather information. You utilize waivers of speedy presentment, where you have somebody go do a delivery in the street to catch the next guy in the chain, have the straw buyer perhaps deliver the firearms to the trafficker and then arrest the trafficker. We didn't have those tools available to us in Arizona because the United States Attorney's Office wouldn't allow us to utilize waivers of speedy presentment before a magistrate. Proffers almost never happened. The basic investigative techniques that I used with great success in the Southern District of New York, Eastern District of New York, and elsewhere weren't being deployed in the District of Arizona.
Well, working with my staff, when we looked into it, straw purchases are typically charged under Section 922 and 924 of the Criminal Code, and these sections make it a crime to knowingly make a false statement. And in this case, the false statement would be when a straw purchaser lies on a Form 4473 when he or she makes a straw purchase. This was the way that they went after straw purchases in other states. Are you aware with this, of these two sections and knowingly making a false statement? Are you aware of that particular?
I am, ma'am. And again, I'll just state that in many instances, these cases weren't prosecuted by the U.S. Attorney's Office.
But I want to get back to the false statement. And what is the false statement they would make on such a form that they could use in prosecutions? Are you aware?
Well, the most blatant one is that there's a box that you check whether or not you're purchasing the firearm for yourself. A straw purchaser clearly is not. They're buying that gun merely to deliver it to another person. The other lies would be sometimes people put false addresses.
And getting back to your statement on the prosecutions, border state U.S. attorneys have complained that district court judges view these prosecutions as mere paper violations. And have you heard this criticism before?
I have, and I agree with it. I think perhaps a mandatory minimum 1-year sentence might deter an individual from buying a gun. Some people view this as no more consequential than doing 65 and a 55.
And the Justice Department.
The gentlelady will suspend. I want to caution the witnesses that the scope of this, your testimony here, is limited, and that is not about proposed legislation and the like, and under our House rules would not fall within the scope of this. So anecdotally, you can have opinions, but ultimately it would not be considered valid testimony.
Yes, sir.
Point of order, Mr. Chairman. The gentleman state his point of order.
Yes. Let me just, the Officer Forcelli in his testimony has a statement, Mr. Chairman, that I read, where he says that these firearms are ending up on both sides of the border. And I think it's only fair that since it's his statement, that she, and that's basically what she's pretty much going to, but
the gentlelady can ask any question she wants within the scope of the hearing. Under Rule 11, Clause 2K8, it's the discretion of the committee as to the breadth of the testimony. Any question related to the operations or the failures of Fast and Furious or factual indications of what occurred in Arizona or throughout the system are within the scope of the hearing. Proposed legislation at a federal level and whether or not they should be changed are outside the scope of not only this hearing, but would not ordinarily fall under the jurisdiction of this committee.
Just to further point the word of order, Mr. Chairman, it's my understanding of the rules is that you can object to the question, but you can't tell the witness what to testify to.
Well, within my time, I appreciate the Chairman's statement, and I appreciate your statement earlier when you said you wanted full answers and full prosecution. And I think it's certainly within the scope of this hearing to understand why we're not getting a full prosecution. And the allegation that they call them paper excuses as opposed to a valid, concrete way to react, I think is a valid way to go forward.
The gentlelady,
I'm supporting your statements.
The gentlelady, if she would suspend for just a moment, the gentlelady's questions and whether or not the gentleman believes that law enforcement was doing its job or that the courts were properly enforcing, and whether that may have led to actions, is fully within the scope. Anything that these individuals witnessed in or around Fast and Furious is certainly within the scope. I only caution, we're not here to talk about proposed gun legislation. It would be outside the scope of this hearing.
Well, I wasn't discussing that. I was trying to figure out why the Justice Department and the IG found that prosecutors often decline these gun cases. I want to know why they're declining them. And to quote from the testimony, one of you said because they believe it is difficult to obtain convictions on these violations and because they believe it is difficult to obtain paperwork from Mexico. And my question is, are these valid excuses not to bring these cases? I think that's a valid question to get to why we're not getting prosecutions in these cases. Are these valid excuses to say they're paper excuses not to bring it?
I believe not, ma'am. And again, to go after the mid-level and upper-level members of a cartel, you need to start, unless you have evidence on them immediately, with the people at the bottom of the food chain. When straw buyer cases are dismissed because of excuses made up by the United States Attorney's Office, as opposed to when you have factual evidence that shows that person's committed a crime, then you can't prosecute that bottom feeder to move up to the next level.
One of you in your testimonies called these laws to prosecute toothless. And could you explain to me why are existing straw purchase laws toothless?
My opinion, ma'am, is that with these types of cases, for somebody to testify against members of a cartel, where the alternative is seeing a probation officer once a month, they're going to opt towards, not cooperating with the law enforcement authorities.
And what would help your interactions with the U.S. Attorney's Office? Mr. Casa, Mr. Forcelli, or others, what would help you be able to be part of getting convictions and bringing those to justice that are part of these straw purchases that led to the death of Mrs. Terry's son?
The gentlelady's time has expired. You certainly can answer that.
Well, I believe first and foremost, they probably need more resources at the U.S. Attorney's Office in Arizona. There are an overwhelming numbers of gun crimes occurring there, and if they don't have the resources to prosecute them, then I would imagine that they would need some assistance in those regards.
We now recognize the gentleman from Idaho, Mr. Labrador, for 5 minutes.